Buckle up, guys. Today we are going to watch a courtroom tension rise fast as Judge Washington confronts Lindsey over emails, filings, and service issues. The judge tries to set order while Lindsey insists she followed instructions, creating a clash between courtroom rules and a defendant who believes the system is stacked. This moment sets the tone for everything coming next.
When did you pay him?
Last time I was brought to court, they made me pay $185.
In this case, or a different eviction?
The first one.
We're not talking. We are not talking about any eviction other than the one you report today. Judgment for the plaintiff.
I wasn't evicted.
I'm not gonna deal with it.
I wanted a hearing. I wanted to try.
This was a hearing, but you can't comply with the hearing because you think you're gonna talk over me. You're not
following why. I don't understand what I should do until I know the facts. Because I mean, why? I don't know if I approve of what I owe because I don't know what I owe when they check on other charges.
You owe $829.54 plus court cost of $178.54 for a total amount of $1,008.08. You need to pay that in full, or you're going to vacate the property by Monday, September 29th, 2025, okay?
I filed for help, so what do I do about that?
You need to, we advised you of your rights when you came last time. We said if you had proof that you had a promise to pay from an agency.
I left it.
Talk over me one more time, I won't bother to explain it.
I have anxiety.
Talk over, okay, well then, if you know what helps your anxiety?
It's not this.
To relax and calm down. So just listen. He said if you have proof that you had a promise to pay from an agency, you need to file that proof within 5 business days.
They told me I had to apply within 5 business days.
That's not what it said.
That's what they said. It was my first Zoom thing.
Ma'am, do you know how many times a week I listen to that video?
She said 5 days.
It says you need to provide proof within 5 business days, not apply within 5 business days.
I did.
And you've not even gotten anything that said that they were going to pay the past due.
I haven't gotten anything from them yet.
Correct. So you need, the judgment's going to enter as of today because you have not been able to come to a resolution. If you do get proof or a promise to pay, you can bring that to the court. And then that way, maybe that the court can withhold the writ if you move to the writ date, or maybe they'll give you an extension if they're going to get a promise to pay. But you got to get the past due rent paid.
So it didn't want to do that until I knew what the total amount was.
The total was $1,008.
But I haven't gotten anything in writing from them yet that that's what it was. I got a $288.
You got a $288?
Yeah.
What do you mean?
When they filed, that's how much the amount said.
Is that how much your monthly rent is?
It was plus some late fees, I think.
$288 is your monthly rent?
$244
plus late fees. Is that accurate, Mr. Garlinghouse?
Yes, Your Honor. And at the time of filing, it was $311.54 that was owed.
That was what
That
month?
was back in July.
It's September, man. We're almost in October.
I haven't gotten anything else from them yet since I filed 2 or 3 weeks ago with DHS.
I don't know why you thought you was gonna get something else from your landlord. What else were they?
You know the total amount that I owe.
You know your rent is due every month.
I know that.
Have you been paying it?
Both months on the beginning of last month, but she filed with the attorney, so I decided not to do anything until I found out what the total amount was due, because if I paid anything, then DHS might turn me down and say, you already paid it, we're not helping you.
Here the judge begins tightening the reins. As a third-party observer, you can see Lindsey's constant interruptions slowly pushing the judge's patience to the edge. The court explains formatting rules and filing procedures, but Lindsey keeps challenging every point. This is where frustration meets authority, and the judge makes it clear contempt is only one interruption away.
You should bring that down to the court, take it to the clerk's office, and then we'll see if we can hold off on a writ date for you, okay?
Okay, can I ask a question?
Yes.
Do you do a lot of the Section 8?
Do I deal with
I just wondered if, because I talked to them on Zoom, I had a breakout session with the attorney and the manager, and I said, I don't know what's going on, maybe it's not a good fit. Do you have to be on Section 8 for a year to be able to be transferred to another, get a voucher to another place?
Well, if you're on Section 8 and you have a voucher, I think you have a lease that you have to comply with, but I know you can't get an eviction on your record if you have Section 8, because that can impact your Section 8.
Right. But I remember the attorney in the breakout said if they forgive the cost if I did, I just didn't.
I don't know. You are on Section 8?
I am.
So then you should have been trying to work out an agreement with them so that you can keep your Section 8, because if you
She
get a
took me out of
judge,
her office when I talked to her, and she filed, I went down to their office and told them I was paying that day, and she filed at 3 o'clock in the afternoon. That's why I was upset.
okay, but
She didn't
if,
wait and
if
told
it-
everybody in the lobby
it
in
was
front of
late.
everybody.
if it was late, she doesn't have to wait till 3. It was,
She said, I went in the office and said I would be down there that day. And she filed before I got there that day. There was another person in the office that gave her that information. So it was like she
okay,
retaliated.
but you went down and paid your rent?
I wouldn't after she filed with the attorney.
If you had to pay the rent,
I had it. I was going to,
she could have dismissed it if you had to pay the rent.
but she did it before I even had a chance.
Doesn't matter.
I thought
If
she did it just to get attorney's fees from me again.
I
No,
can
it didn't
guarantee
make
you,
sense to
I
me.
can guarantee you, they're paying more than what you have
I
to pay
haven't seen those
attorney's
attorneys.
fees. It's
I haven't
costing them
seen or
money.
heard from those
It is
attorneys.
costing money for them to hire an attorney. And the statutory attorney fee that they're imposing upon you is not the cost that they're expending to hire legal counsel.
Yeah, but I've never seen their legal counsel. How do I know they're doing that and not just giving me?
It doesn't
paperwork?
matter. They're not representing you.
No, but you know what? They should show proof just as well, right?
They
If
know
I'm
they
paying
don't.
them-
No, they shouldn't.
If I'm paying them, they should.
You're not paying their attorney.
I was.
No, the court is imposing a statutory attorney fee because you required them to get an eviction. They're,
No, I didn't.
yes, you did. You didn't pay your rent.
I told her I'd be there by 5.
Okay, you're all
She
set,
filed at
ma'am.
3.
You can be excused.
So that's ridiculous. I'm sorry. I don't mean to disrespect you. I really don't.
I
just
can't help, you I can't explain this anymore to you.
I don't understand. I'm
Okay,
sorry.
I get it. Then you need to go and seek counsel to get someone to explain it to you. And he is not your attorney, he is their attorney,
He's
okay?
not-
Now the situation escalates. Lindsey's own attorney steps in, calmly explaining she refused to file the sovereign-style motions because they were legally incorrect. Lindsey pushes back, claiming she is asserting her right, not requesting, which only deepens the divide. The judge tries to regain control, but the growing resistance signals this is about to get much more intense.
They haven't done anything for me.
They're not representing you.
But you know what?
They represent the landlord.
It should be unfair. She filed it $288.
I don't know what you're talking about. That has nothing to do with this case.
Why? She's part of the case.
Who's
I don't
she?
understand.
Who is
The
she?
manager of the apartments.
They are suing you.
I know.
The
And they
attorney
shouldn't
does
have,
not
because I told her
represent
I'd be there
you.
that day to pay it, and she filed at 3 o'clock in the afternoon with the attorney.
The
Why?
attorney
So
does not represent you, ma'am.
I didn't say he did, but why am I paying him?
The
then? I
information
do-
about what?
I don't, 'cause I
Ma'am,
filed
ma'am,
for-
ma'am, I asked you a very
I
specific
did.
question.
I'm trying to answer you.
No, you didn't. Do you have a lawful reason to withhold the rent?
Not all the rent, but the court fees and the attorney fees and all that. And
What's the
plus, I'm
lawful-
trying to get help.
What is the lawful reason?
The lawful reason is because I told her I'd be there that day to pay both months. I got robbed and beat in the head on the riverfront the month before I got behind. I went in the office that day,
Well,
told her
those
I'd be
don't
there that afternoon, and she
Those are
filed.
unfortunate reasons, but they're not lawful reasons. So a
But-
lawful reason to withhold the rent would be like,
And I just say,
ma'am, the lawful reason will be something like there was, you were illegally locked out of the property, or there was a condition with the property that infringe on your ability to enjoy or stay in the property, like a health condition in there. Not, what you're talking
There-
about is personal.
no, not, it was the riverfront part of the property.
Excuse me?
Is the riverfront where it happened part of the property?
No,
Well, there is another reason, there are other reasons, yeah.
okay, well, I asked you what the lawful reason, I only want
I don't know
lawful
what,
reason.
I don't know the law you guys do, but I knew that I had to file for help by the 5 days after the last one, and I did. And when I got here, I haven't gotten anything from DHS yet responding to me yet. When
Okay,
I
so
got
you're,
here, I realized I
so
didn't have my phone, so I can't.
you're
prove
saying
it.
that you applied for
Yeah.
help with DHS, but the video said if you applied, you had to file proof within 5 days.
I called the court though, and they said
Where's
to
the
bring it when I
proof
came
that you filed?
here.
Oh, did you get paid more than
And
$200?
They weren't even here. They weren't even here.
Do you get paid more than $200 to be here?
Yeah.
I sure hope you do.
They were not even
Do you
here.
know how much his hourly rate is?
Why are you saying I don't have to pay, and then you're saying that?
I didn't say you
I
didn't have to
didn't
pay. There's a statutory amount if you are evicted or there's a judgment against you, there's a statutory amount that's imposed, but I can guarantee you it only covers his gas money.
Things hit a breaking point as the judge orders a competency evaluation. From the outside, you can see Lindsey spiraling into jurisdiction arguments, accusations of retaliation, and claims of innocence. The judge stays firm, warning she will be jailed if she refuses to comply. This is pure courtroom meltdown energy, authority clashing with defiance in real time.
You have not provided the court with a reason under the law that I can grant your request to object to the garnishment. Yes, ma'am, you can respond.
Okay, just to correct the record, Your Honor, it was actually a summary disposition judgment that was entered in 2023, and it was also entered pursuant to the notice of 7-day rule for entry of the order. So defendant had notice to appear for that hearing through plaintiff's notice of a hearing. They had an opportunity to object to the entry of the summary disposition judgment. They didn't file a response to plaintiff's motion for summary disposition judgment. And as Your Honor had already stated, it's not a proper objection to writ for garnishment when you're attacking the validity of the underlying judgment under the court rules. So it's plaintiff would ask that you deny the objection is invalid and appreciate that you've done that.
I'm trying to explain so that the Ms. Brown can understand her concern, because I'm not saying that there's no other avenue for you to go and try to figure out what happened with your notice, or according to what they filed, you were served with a notice for your date to appear in court. And outside of that, you knew you were being sued. And so when you appeared in my court in 2022, there shouldn't be a next appearance 3 days later, or 3 years later, that is. You should have appeared at some point wondering what was going on with your case, because you knew you were being sued. And they had served you with discovery. They had served you with a summary judgment motion, which the court told you when you saw us would have a deadline date. And so we advised you of that when you were last here in 2022. When you didn't respond until this objection, and you can't now attack the judgment because the court rule says you can't do it this way. And so I have to deny your motion. Okay. Okay, so if you want to, I don't know what the balance is on the debt, and I know you said that you had some other garnishments that took place. You could try to meet with Ms. Servey and see if you all can work something out and maybe enter an installment payment agreement or another kind of settlement agreement that will prevent them from trying to garnish your wages. So if that's what you want to do.
A new case opens, and Ashley Brown steps in with a challenge to wage garnishment. As an observer, you see the shift instantly. Ashley argues she wasn't notified, but the plaintiff's attorney calmly presents evidence showing she personally signed the green card. The tension becomes less chaotic but more legally sharp as Judge Simmons prepares to cut straight through confusion.
So notice was sent for you to appear in court on March 28th, 2023. You did not appear. Outside of that, wait, I'm not done yet. Outside of that, ma'am, once you fail to appear, a default judgment entered against you, and the court then sent a notice of a default judgment to that same address.
Did not receive that.
So the court itself sent multiple notices to the address on file notifying you of A, to appear in court 2 years ago, B, that you failed to appear and a default was entered. Once that happened, that allowed you the opportunity, if you had responded to even the notice of default, you could have came back to the court and request to have the default set aside, but you never did that. And that's quite common. We get a lot of people that ignore that paperwork, and then we hear from them once it's time for their garnishments to take place.
Is it my turn to speak?
Yeah, we haven't heard anything we haven't received or heard anything from you on this file since October 12th, 2022.
I did not receive a notice for judgment. I did not receive any notice for judgment. I don't know if there was lost in translation because I was fighting the case. I definitely wouldn't have not appeared to that hearing.
Ma'am, you were advised by this court that you were doing a joint pretrial statement and that you would have some dates that would be kicked out from the clerk's office. You knew you were being sued.
I was advised of it, but that doesn't mean I was served.
What did you think happened after the next 3 years after you came to court? What did you think happened?
To be fair, like once I did receive the notice once I received the information about the garnishment, I honestly thought that they closed the case because they garnished my taxes. But I still was not notified of any of those things. I don't
I'm
understand,
not
like I
sure
said,
what you
how am I
mean you weren't
supposed to
noticed.
respond? Because I would have responded to the garnishment way before now had I known about it.
Your tax garnishment is what you're talking about?
Yes, they garnished my taxes, but I did not know that.
Okay, so and that's not even what you're here for today. You're here for a different garnishment, correct?
I mean, it's all of them because, like I said, that's not the first one that they did. They did multiple garnishments or at least attempts, but there was never any notification sent to me. How am I ever going to? I mean, how am I supposed to respond to a garnishment if I don't have any notice of it? I only responded to this one because I literally received a notice.
Here, Judge Simmons breaks down the reality of garnishment law. Ashley insists she was never warned, but the judge shows the court rule leaves no room for that argument. She explains missed court dates, default judgments, and long periods of silence. Watching from the outside, it's clear Ashley is cornered by facts she hoped the court overlooked.
Ma'am, you were served with the lawsuit in this matter, correct?
Uh-huh.
And then you appeared before me back in December 1st, 2022. There was a joint pretrial statement that was completed. After that, you received your next court date. You were supposed to appear in this court on March 28th of 2023. That's over 2 years ago. You failed to appear. Default judgment entered against you
I did not
because
get
you failed
notice
to
is what I'm
appear.
saying.
You failed to appear. You knew you were being sued. You were properly on notice that you were being sued, and the court sent the notice to appear for your next court date. That came from the court, and it did not get returned back to this court non-deliverable. If your address changed from the time that this court case began, it would be your responsibility to then go and notify the court, but it doesn't even appear that your address changed.
Ashley tries hard to convince the judge she never received notice of her judgment, but the timeline works against her. The judge lays out exactly what happened: service, pretrial, missed court, default, and mailed notices. As an observer, you can feel the judge's frustration as Ashley keeps repeating the same argument, trying to rewrite a history the court tracked step by step.
But you are still required by Michigan rules to notify me to. I'm sorry.
Ma'am, that's not how this works. You see how I asked her if she wanted to respond?
I understand. I'm sorry.
Okay, that's why I'm here. I'm the referee here. I get to mediate this. So you don't talk back and forth, you talk to me. So a court rule for your objection to garnishment is very clear. And there's no court rule that allows or tells you that you can even file a garnishment. That you see where you request the objection, and it gave you a section A, B, C, D, E, and F. Okay, and that's because those are actually the only ways in which the court rule allows you to object to a garnishment. You checked F, which allows you to say that the garnishment or the writ of garnishment was issued improperly or otherwise invalid, and then you wrote in that it was because it was improperly notified of any. You wasn't properly notified of any hearing. There's no hearing that comes with. You're opening your mouth to talk over me while I'm talking. There's no hearing that comes with a writ of garnishment. So I don't know what hearing you were looking for. There would have been no hearing. The other thing is, you said that it was not issued, or that writ issued after the initial hearing. Again, I don't know what you mean by initial hearing.
It's my turn to speak. I'm sorry.
That's correct. Yes.
So when I wrote this, it's because I literally was not notified of any other hearing even leading up. That's what I meant by hearing. So like, I understand that they issued the writ of garnishment, but I was never notified about a hearing for the judgment or any of these other garnishments. Like how am I supposed to respond to a garnishment if I don't have this, if I wasn't served?
Now the ruling becomes unavoidable. The judge and plaintiff's counsel confirm the judgment was legally entered, and the objection can't challenge that. The judge denies Ashley's objection but still offers practical advice, suggesting negotiation or installment plans. It's a mix of strict law and controlled compassion, and you can see Ashley finally realizing the legal road has closed.
Did you want to respond to her objections, counsel?
Yes, Judge, I will. plaintiff had the writ of garnishment properly issued. It looks like that was back in July, so July 23rd, 2025. The writ was issued by this honorable court and then served on Garnishy Michigan Funeral Directors Associations, Inc. There's no court rule or statute or case law upon which plaintiff is aware that plaintiff is required to give defendant prior notice of filing its writ for garnishment, but the writ was otherwise properly issued by this court. And plaintiff would further note for the record that it sees that defendant was the person who signed the green card on the delivery of the
Yes.
writ of garnishment, and plaintiff still has not received the garnishment disclosure pursuant to that. Good afternoon, Judge. Francesca Servi for plaintiff P87205.
Okay, you're Ashley Brown.
Yes, I am.
Okay, today was the date that was scheduled for a hearing. This is for an objection to periodic garnishment. We received an objection from you, Ms. Brown. It states that you are objecting to garnishment because you was improperly notified of any, does that say hearing?
Yes. So I did some research, and it appears that they reached out to a few of my other jobs like Kirchhoff, Champion, and I didn't get any notice of any of those. I feel like the only reason I got this one is because they sent it certified mail, and I handle all the mail for my new job here at the Funeral Directors Association. But they garnished my taxes. I was not notified of any of that. When I've only found out that they garnished the taxes when I called the courthouse when I received this notice, because I was like, because they did, I saw the taxes were taken, but I didn't really look into it. But then I called the court once I received the garnishment, and they were like, oh, well, they garnished your taxes for this particular matter. But I was never given any notice of that.
Another case begins and emotions hit hard. Andrea explains tragic personal reasons for falling behind on rent, but the judge asks for a lawful reason, not a painful one. As a viewer, you feel the disconnect immediately. Andrea's story is heartbreaking, but the judge must follow housing law, turning a personal crisis into a legal conflict that can't be resolved by sympathy alone.
Me to present to you that I'm mentally fit, that's fine. But for you to say that I have to have a competency evaluation with no cause because I'm asserting my rights, that's a violation of Scherer versus Cullen. All I'm doing is asserting my right to represent myself.
Referred for competency. We'll prepare an order so she can be evaluated so we can determine.
Well, I object to that. I object to the competency evaluation.
You want to object to, but if you don't participate, then I'll put you in custody until we get an exam done.
But why? But you have to say that there has to be a reason. There has to be a cause for it, and I have a right to know why you are forcing me to do something that I don't want to do when I thought I had a presumption of innocence. I thought I'm supposed to not have my right.
For competency, you need to stop talking. And if you don't participate, I'm going to put you in custody. And I already placed on the record why.
Okay, and also, isn't the officer supposed to be here today to testify?
No, that is not how that works. See, you don't know anything about this, and that's why you shouldn't be representing yourself. But
I do. The preliminary exam was supposed to have witnesses.
This is not a preliminary examination, ma'am.
Oh, I thought that's what that was. I was just under the impression it was a preliminary
competency. And I'm going to schedule this for a hearing on November 20th in person, so we can have these conversations in person and see if they go any.
Well, I don't have any way to get there. I live very far away from where this is now.
Then I think when you get picked up and you're required to come here by police, then you'll have a way to get here.
Why would that be necessary? All I'm asking, I'm challenging jurisdiction, which I'm allowed to do without being retaliated against. You're retaliating against me because I'm challenging the jurisdiction of the court. And that's a violation of my rights.
Okay. Ms. Duneske, you either need to be here, you need to participate in the competency, and you need to be here on November 20th, or you will be.
I'm going to be filing with the Court of Appeals on this.
Go ahead, ma'am.
And the Court of Claims, because this is not okay.
All right. Bond is continued for now. Once you get the notice of your actual interview from the forensic department, if you don't participate, I'll issue a bench warrant.
Okay, well, like I said, I'm going to be objecting to.
Confusion takes over fast. Andrea insists DHS told her to apply within 5 days. But the judge quotes the rule exactly. She needed to provide proof. You can almost feel the tension sharpen as anxiety meets procedure. Andrea tries to explain her side while the judge repeats the same instruction, and both of them grow more frustrated by the minute.
I understand Ms. Duneske does want to proceed with these arguments, and I believe that she's requesting to represent herself if this court sets this for a motion hearing.
Now, Ms. Duneske, are you requesting to represent yourself?
Well, I'm asserting my right to represent myself. I'm not requesting.
All right, then if you're not requesting to represent yourself, then what's going to happen is you're going to continue to have counsel.
Well, I'm asserting my right, which is much stronger than requesting. I shouldn't have to request something that I have a right to. It just should be automatic, right?
All right.
Like the Sixth Amendment
It is not,
and the Constitution.
it is, ma'am,
Yes.
it is not automatic. So first
I mean,
of
the
all,
Sixth
ma'am,
Amendment says,
stop
right?
talking.
Well, you asked me a question. I'm answering under
No,
the Sixth
I heard
Amendment.
you. No, stop talking. So look, this is the way it's going to work. I'm going to give you what your rights are. And then if you make a choice to represent yourself, you can, after I've finished giving you those rights. Do you understand that part?
I comprehend it.
Okay.
Yes, ma'am.
So, first of all, what you're charged with is police officer assaulting, resisting, obstructing. It's an attempt. It has a maximum penalty of up to 1 year in the Washtenaw County Jail. Do you understand that part?
I comprehend that that's what you're charging with. I don't understand it because it's false.
Okay. Do you understand that that is what the maximum penalty is?
I do, which is why this is unconstitutional, because I was the victim in the case and falsely
All right, I
arrested.
think what I'm going to do is refer her to make sure she's competent, because at this point in time, if she can't understand and she wants to use a different word, then I guess what I need to do is figure out what.
Comprehend means that I know
Yeah.
what.
Judgment drops. The judge lists the exact rent owed and the deadline to pay or vacate. Andrea continues to question fees, previous filings, and attorney actions, but the judge keeps redirecting her to the current case. Watching from the outside, you see a tenant overwhelmed by the legal system and a judge trying to keep her focused on the only issue that still matters.
Yes, Judge. I mean, I'm just opening up one of the files now. I mean, I would need time to review all of this. I would not be able to. Yeah, I would need time to review all of these, Judge.
Thank you. All right. So first of all, Ms. Duneske has counsel. So whether or not she should or has the ability to file filings in the first place is something I'm still mulling over, because she has counsel. So any pleadings should come through her counsel. And
Yeah, they refused to file it. So,
ma'am, I didn't say.
oh, I'm sorry. I apologize.
And then, secondly, these are not proper pleadings. They're not filed in the proper format. They're not filed with the proper spacing. They're not filed according to any of the court rules. So that's
They don't have to be, though.
Ma'am,
which I put on there.
Ma'am, if you speak up one more time, you're going to be held in contempt of court.
But I thought this was my hearing. I should be able to speak on my own behalf.
You're not able to speak on your own behalf unless you don't have counsel, and you need to stop talking. One more talking, it's going to find you in contempt of court, and I'm going to give you 15 days. So please stop talking. Ms. Woods is indicating that she needs time to look at those pleadings and to be able to respond. Ms. Moeller, what is your position? I haven't heard anything from you today, because she actually has.
Thank you, Your Honor. Mr. Duneske and I did, prior to the last pretrial, discuss. I didn't know exactly what she was going to be filing, but I did understand the basis of her legal argument. Her and I had a conversation where I didn't agree with the grounds for filing. It is correct that I said I would not be filing this on her behalf because I found the legal argument not to be correct. At this hearing, then Ms. Duneske did file these motions, and so I would discuss it further with my management, but I would not be proceeding with these arguments at a hearing if the court were to set it for that.
We're back on the record in the case of the state of Michigan versus Lindsey Duneske. You don't need to place your appearances back on. We had a brief discussion regarding all of the filings that were filed, although the defendant has and an attorney in this particular case. So at this point in time, we need to make a record of what's going on in this matter, and we can go from there. Ms. Moeller, it looks like your client submitted 4 different filings. First of all, the court has no requirement because we're not a email e-filing court to accept email pleadings. We did do so. Your client was advised that there is a page limit to how much we'll accept for any one hearing. So that happened, and you should be aware that that did happen as well, and that she will need to follow any filing requirements in the future. And I believe that she represented to staff that she had filed those with the prosecutor's office. Ms. Woods is indicating she did not receive them. I don't know whether they were filed with the prosecutor's office or not. Having said that, do you have a copy of the filings that your client filed with the court?
They do, Your Honor. I received those. Those filings were sent to the court, and just now, realizing they were not sent to prosecution, I have forwarded those to Ms. Woods.
Thank you.
I sent them to the other prosecutor. I apologize. Her name was Ellie, I think, because that was the one who, it said she was the prosecutor for the county. So I just probably sent it to the wrong prosecutor.
So it is a he. That is the
Okay.
chief prosecutor, Ellie Savitt, and they probably did not get sent to the proper place because of the way you filed them.
I filed them the way I was instructed to file them. I called and asked for instructions, and I did what I was told. So I was told that the filing requirements were to email them, and that's what I did. So, and then I was notified after the fact that there was a limit. They made an exception because they didn't notify me. And then I told them I emailed the prosecutor, verified the email. And so as far as I know, the chief prosecutor got them. I just didn't know that I was supposed to send them to the other prosecutor too. I thought,
The final spiral unfolds. Andrea insists the landlord filed early to trap her with fees, and the judge counters every claim with the actual law. As the conversation breaks down, the judge finally ends the hearing, telling her to seek legal counsel. This is where emotion, misunderstanding, and strict rules collide, closing the day with a tense and unforgettable exchange. All right, guys, if you enjoyed this breakdown, make sure to like the video, drop a comment, and subscribe to the channel. We'll see you in the next video.